Thank you for making the time and for being on time. We're going to start because we do have a very packed day. So my name is Mwendengao and I'm going to be a moderator for the day. Today we're going to be tackling the role of tech companies in the protection of human rights. We have a great list of speakers and it's going to be a great discussion. So first things first, we're going to have some welcome and introductions from Kennedy Kachwanya from the Bloggers Association of Kenya. Welcome, Kennedy.
Thank you, Mwende. I hope you can hear me.
Yes, I can hear you loud and clear.
Okay, thank you. And I take this opportunity to thank everyone who has joined us in good time. I know some people are still trying to get in, but we promise to start in time, and we have to keep promise for those who have joined us in good time. This project on digital human rights is something that we have done as a project for a while. And if most of you can remember, there are times when we had a problem with the Computer Misuse Act, which we tried to ensure that the clauses that we thought was problematic were corrected. It's still an issue, but we are glad that there's some progress in that end. But when you come to other side of this project is the issue of how businesses treat both the public, the clients, the employees, and that's why we feel that digital rights is an issue that is so important to BEC and our members. And this also includes the issue how the internet as a whole is governed. And that's why today we are trying to look at the role of tech companies in the whole aspect of human rights. But the other aspect of this conversation is the National Action Plan, what we call NAP. And later on, we'll hear from somebody about this. A National Action Plan is a document that Kenya been working on, and we are in an advanced stage, and we'll hear the status on this. And what it entails is it entails the entirety on how businesses treat the human rights issues. So we will hear that as I've mentioned. And also we have very good speakers today. I'm just glad to see that already we have Madam Commissioner, Data Protection Commissioner already joined us. We have Madam Kui Kinyanjui from Safaricom has already joined us. I can see we have Ephraim Kenyanito from Article 19 has joined us. I think I can see Samuel Mbugua from North Africa has already joined us. I welcome you all, guys, and I think we are going to have very good discussion. When I'll get it back to you.
Thank you so much for that welcome, Patricia. I am looking forward to also learning a lot. I've noted the speakers are amazing, as you've said. So without further ado, let's get into it. Our first speaker is Ms. Immaculate Kassait, the Data Protection Commissioner, and she will be speaking on data protection regulations and their impact. Welcome.
Thank you. The organizers, I want to appreciate. I know this is, we agreed to take on this quite within a short notice. We even had clashing meetings, but we are happy to be here. And I really want to appreciate the leadership of the Bloggers Association of Kenya. And of course, you know, today we are in the digital era, and we continue to rely a lot more on our social media platform as a way of disseminating information. We always like to contextualize data protection, and data protection, I mean, the data protection within the Vision 2030. As you can see, the overarching issue around Vision 2030 is to making Kenya a globally competitive and prosperous nation with high quality of life by 2030. Under that, we have three pillars. That is the economic, social, and political pillar. Under the pillars, we have the enablers. And the enablers, one of the enablers is ICT sector, where we call for a vibrant ICT sector. And also ICT is positioned as a critical driver and enabler of Kenya's social economic development. Next slide. Having spoken about Vision 2030, the ICT sector has what we call the Kenya Digital Economic Blueprint. Many people ask, where do you, because you see in government, you classify different regulators in different aspects. For the purposes of we as a regulator, data protection, we fall within the Ministry of ICT. And why do we fall within the Ministry of ICT, or why was it important to have a specific framework, legislative framework dealing with data protection? This emanates from the Kenya Digital Economic Blueprint. The Kenya Digital Economic Blueprint, which was launched in 2019, has five pillars. First is digital government, making sure that government activities are digitalized, digital business, digital infrastructure. There's also infrastructure. The infrastructure touches on the fiber, and then there's innovation-driven entrepreneurship. And we have that, and what we like to call young people being given an opportunity through a JIRA platform, and also Ministry of ICT Authority also encourages what we call a white box or sandbox for purposes of innovation. Then there's digital skills and values. And you see below that, of course, we have the policy and regulatory emerging trends and data. And below that, we have government, we have citizen, and then we have private sector. And when we look at all this, we are looking at an integrated ecosystem, of course, ICT green, and of course, security. The cross-cutting issue in these pillars is actually data. Data being a cross-cutting issue then makes it important for the government to put in place a framework that actually addresses data protection. So based on that, in 2019, I'm moving to the next slide. In 2019, the Data Protection Act 2019 was enacted. And then in November, in order to operationalize the Data Protection Act, in 2020, the Office of the Data Protection Commissioner was established. We are slightly over 10 months. We should be hitting our first year anniversary in November anytime. The Act basically provides for the framework for the rights of the right to privacy when it comes to application of personal data. It provides for the practices, safety rules, and transparency and responsibility. Basically talking about how we collect data, how we process data, how we store data. And of course, the most significant thing to note about, one of the important things to note about the Act, it shifts control from institution to the data subject. Next. What is the mandate of the office? We have summarized the mandate of the office into 5. We regulate the processing of personal data. We ensure that the processing of personal data is done in accordance with the principles of Section 25, which I'll be speaking to later in the presentation. We protect the privacy of individual. We establish legal and institutional mechanisms to protect personal data. We provide data subject with rights and remedies to protect their personal data from processing. That is also done in accordance with the Act. Next slide. The mandate of the office: 1, we are an enforcement and implementation. As a regulator, we are supposed to enforce and also ensure that the Data Protection Act is implemented. Registration of data controllers and data processors. Once the regulations come into force, at a given time, we will be expected to have all the data processors and data controllers to be registered. We offer oversight to ensure that the data is being processed in accordance to the provision of the Data Protection Act. We promote self-regulation, and I see today we are speaking to Bloggers Association. Perhaps it's time for you to also think about what self-regulation would mean for you. We conduct assessment, and in the event there's a data breach or a complaint, we are empowered to actually undertake investigations. Next slide. Creating awareness, and this is part of awareness we are having this session today. Inspection, international cooperation, research, and what we like to say, any other duty. Quickly running through the draft regulations. In January of this year, the CS, ICT and Innovation and Youth, Joe Mushero did gazette a task force, which was drawn from different government agencies. And the task force was tasked with, amongst other things, to come up with draft regulations to be able to operationalize the Data Protection Act. We have draft regulations, the Data Protection General Regulations. That is one set. This one basically sets out the procedure for enforcement of rights of the data subject, as well as elaborating the duties and obligations of the data controllers and data processors. 2, we have a Data Protection Compliance Enforcement Regulation, which basically outlines the data protection, the compliance and enforcement provision. So I was explaining in terms of the draft regulations where we are. After we held a stakeholder consultation, we then retreated to incorporate comments. In June, we had a meeting with the Senate Standing Committee. In August, we had a pre-publication meeting with the Committee on Delegated Legislation of the National Assembly. The next steps basically are publication, because the Attorney General has to publish this, and then the regulations will be officially tabled before the Committee on Delegated Legislation. So that is the status of the regulations. Next slide. Just to go through, because people keep asking some of you may be hearing this for the first time. What is a data subject? Data subject basically is a natural person. It's me or you. And basically what the data that has to do with me as a person is what is called personal data. So when we say a data subject, you're the subject of personal data. And personal data in this case is your name, your gender, your marital status, your health status, anything to do with your conscience, anything that actually describes you as a data subject, which can, if I look at it, it can actually identify you as a person. The data controller, it can be a natural or legal person, public authority, agency, or any other body, alone or jointly with others. They determine the purpose, the means of data, of processing of personal data. And I'll give an example. An example of a data controller could be a hospital. When you walk into a hospital, you fill in that form which says my name, my gender, my age, where I live. The fact that the hospital is collecting that information and making decisions on what to do with that information is what makes them a data controller. A data processor, on the other hand, is all those, whether a public agency, illegal or otherwise, they process data on behalf of the data subject, meaning the hospital, after they have collected the information, they can then seek the services of a research company to do for them analysis of the trend in terms of disease, or in terms of the frequency, or in terms of how many people come to the hospital. Now, the person who is doing that analysis for them, who they have outsourced, becomes the data processor. So that's the link. One collects the information, the other one you can move to the next slide, makes a decision on how this information will be processed. Next slide, please. Next slide. The next slide, I'll be talking about obligation of data controllers and data processors. One of the obligation is registration. Under the Section 18 of the Act, the data controllers and data subjects are required to register with the data commissioner. I've said we've stipulated it in the regulation how the process will be done, and as soon as the regulations come into force, within a stipulated time, data controllers and data processors will be required to do that. So the question you need to ask yourself as an association of bloggers, are you a data controller or a data processor? And do you handle personal information? The next one is the obligation. What are the obligations for data controllers and data subjects and processors? One is to adhere to the principles under the Data Protection Act, but broadly speaking, every activity you process must be lawful and for legal purpose. The rights of a data subject are paramount. Please remember, when I started this conversation, I did underscore what the difference now in the Act. The Act shifts some control from institution to the data subject. So the rights of the data subject, which I'll be going to in the next slide, are paramount. So as you process data as an association of bloggers or as your membership, they need to ask themselves, am I taking into account the rights of a data subject? The privacy by design by default. It means that when you put in place systems, whether it is how you're handling your information, you must make sure that at the point of collecting information to the point of disposal, there is privacy by design or by default. Who has access to this information? How do you store the information? How do you dispose the information? So quickly running through the rights of the data subject. One is the right to access their personal data. A data subject can write to you and say, excuse me, I want to see the information you have about me. And you're obliged under the act to make sure that person gets the information you have about them. Two, you can be blogging about somebody and processing the information. They can write and say, I do not want you to process my information in that manner. And they can do, and you actually are obliged under the act not to process the information. Three, object, they can actually process object to. One is to restrict, tell you can only do A or B with my information. In the case of bloggers, I may not have an example, but let me take a health institution as an example. If they collect my information and they tell me they want to process my information, and processing in this case, they'll be doing an analysis of what my status is, what are the likelihood of the frequency of whatever the case anyway. I can tell them I agree to A and I don't agree to B. So that is restricted processing. And I have a right to actually object to the extent to which they process my information. The right of rectification would mean that if you have information about me, for instance, if you call me female and I am male, you need to rectify that information. Now, for instance, you said I was married and I'm single, I can write to you, and I think this applies a lot to the Association of Bloggers, right to rectification. I can write to you and you rectify my information. The other one is data portability request. I can write to you as the Association of Bloggers and ask you, can you give me the information you have about me, and I'm able to take it away and share it with another person. That is mostly when it comes to, for instance, in the case of what will I say, a bank. With this set of regulation, you can actually walk into any bank and ask for the information they have with you, and then you can carry it and share it with another. Or a hospital, walk in and ask, what information do you have about me? They give you the information and you take it to the next hospital. And then a right of erasure, or what we also call right to be forgotten. I can write to you and tell you, I want you to delete my information. Of course, this comes with some conditionality. Even a legal obligation, for instance, you can't be involved in criminal act and expect that your information is going to disappear. But I can write to you as a blogger and say, I have the right to be forgotten. And you are expected to remove the information you have about me. The principles, I spoke about the principles under the Act. Quickly to speaking about them: lawful, fairness, and transparency. You process information based, you have to give a reason why you're processing my information. Is it lawful? Is it fair and transparent? Purpose limitation. It has to be for a limited purpose. You can't be collecting information for unlimited reasons. Data minimization, you don't collect information from me that you do not need. For instance, I like to say, if I was insuring my car, why do you need to know my marital status? You don't. And why? That is data minimization. You only use information that is absolutely relevant for the activity that you're processing it for. Right to accuracy, I'm entitled for information being accurate. Limited storage of limitation, it means you can't store my information in perpetuity. And in this case, what it calls for, as an institution of Association of Bloggers or as your members, they need to explain how long you're storing information about me. Because if it is 3 years, after 3 years, you need to dispose that information about me. Integrity and confidentiality, this is by default or design. It means it is a common word used in the ICT language in field, where we say when we collect information, we guarantee you that only authorized people will access it. And we are trusting that you will give us your information because we'll secure it. And of course, accountability is to hold you accountable in terms of as far as the information you're collecting on behalf of other people. So those are the 7 principles in as far as the data protection, and it's what you're supposed to actually follow when you're processing data. Then there is the part on accurate. This is a lawful basis for processing information, which I gave earlier. And a lawful basis, some of the common bases that you can rely on is consent. If somebody gives you consent to use the information, that is an important. Contractual purposes. If you're entering into a contract, one of the reasons why you'd be processing the information is because you're processing it for a purpose of contract. For instance, in the case of a bank or an insurance, for them to give me the insurance policy, it's a contractual obligation. That's why they're processing my information. Compliance with the legal obligation. For instance, if your information is being collected for purposes of the national ID or Huduma number, it's for purposes of a legal obligation. That's why they're processing information. For legitimate interest, that is one of the things people keep talking about. There's also public interest, which many times I know as bloggers you would use or rely on to say, I am processing this information, I am sharing a story or blogging about it because of public interest. This is a very common issue that it's actually you can rely on when it comes to processing personal information. Then there is an issue of consent. The Data Protection Act and the draft regulation place an onus on the data controllers and data processors to ensure that they obtain consent. It's not the other, please remember, it's not the other way around. I'm not the one expected to say, I gave you my consent. No, it is you as a blogger supposed to show that you actually sought my consent. And what do we mean by consent? It means that you have informed me in a very simple language and I understood. And the consent for you to share information about me is voluntary. And I had the capacity to understand that and I communicated the consent. Consent is a critical issue when it comes to processing of personal data, and I have also told you what is required. Privacy by design and by default, I have talked about it. This means basically that when you're implementing the principles of data protection, that you're going to do them in principles in an effective manner. You'll integrate safeguards, and you'll ensure that the personal data necessary for each specific purpose is processed by design and by default. From when, and I like to give an example. For instance, if you are working for a company that was collecting personal information, how do you collect that information? Is it encrypted? What are your policies? What are your governance issues? How will the information be stored? How will it be disposed? And you saw recently, and this is not unique to Kenya, that people can actually take up a computer and retrieve information. You as a blogger have to ask yourself, eventually, when your computer reaches its life end, if you had information on personal data about individual, you just have to make sure nobody else can reconstruct it. So that is the design or by default. At the point of collection, processing, and all the way. And then duty to notify is also an important aspect of data protection. You have a duty to notify the data subject. And this also goes hand in hand with consent. If you want to collect information about me, you need to tell me about my rights. You need to tell me that you're collecting my personal information and the purpose. And if you're sharing it with that party. So it can't be business as usual that you come and say what people like to fill a form, information, and then after that you go and use it and share it with a third party without my consent. You have to tell me at the point of collecting information on myself that after I collect this information, I will then share it with a third party. Okay, next slide. Yeah, this is still duty to notify the contract, security measures you put in place. It must be voluntary or mandatory. Data transfer. Data transfer is a concern of many countries, many companies that are multinationals or moving information from one country to the other. What is expected of them in as far as data transfer is one that they have to make sure that the country they're transferring the information to has the necessary safeguards, that they have commensurate data protection provision, and also you must seek the consent of the data subject before you move the information from Kenya to Uganda, for instance, or from Kenya to Europe. You must seek their consent. Then finally, there is the data protection impact assessment, and the data protection impact assessment is conducted when you're having a high-risk project, and you're supposed to submit 60 days prior to commencement of the processing of activity. We're supposed to get the data protection impact assessment. Of importance is to remember the data protection impact assessment. We look at it as a tool for decision making, where you're able to assess your risks and tell us how you will be able to deal with the risks. And finally, in terms of the way forward, one, it's important for you as an association of bloggers and your membership to appreciate the Data Protection Act. Two, you adopt practices that take into account the principles, rights of data subject, and safeguards. I've spoken to them in highlight. And of course, undertake a data protection impact assessment if you're undertaking a high-risk project. Document any data breach. For instance, if there was a hacker who hacked into your system and there was a breach, you need to report to us within 72 hours and also tell us what you're doing as far as mitigating the process is concerned. And finally, collaborate. I'm very pleased to have been part of this session, and I really do want to appreciate. Kennedy, back to you. Thank you very much for this opportunity to address your matters data protection.